Hi, I'm JC Sakorda and I'll be discussing with you the torrent system. This will be the first of a series of mini discussion about land titles and deeds. In this discussion, I'll be uh, giving an overview about the torrent system, its purpose, the governing law, and the proper court which has jurisdiction about the torrent system. Let us begin. We have three objectives for this discussion. First is to define and identify the purpose of the torrent system. Second is to discuss the nature of the torrent system and the court which has jurisdiction over it. And third, to identify the governing and applicable laws to the torrent system.
Wow!
The definition of the torrent system, as can be gleaned upon or from the Black's Dictionary, it is a system for registration of land under which, upon the landowner's application, the court may, after appropriate proceedings, direct the issuance of a certificate of title. As you can see, the torrent system is judicial in nature because it says here the court. And in other words, it refers to the system of registration of transactions with interest in land whose object is, under governmental authority, to establish and certify to the ownership of an absolute and indefeasible title to realty and to simplify its transfer. This system was devised and first introduced in South Australia by Sir Robert Torrens in 1857, hence the name Torrens system. The torrent system, which is the Philippines registration of land, is based on the generally accepted principles underlying the torrent system. And with the onset of the torrent system, it resulted as well with the discontinuation of the Spanish mortgage law. In this law, well, it will be discussed later on in other mini discussions. It is where lands registered under the Spanish law. As we can remember in our history, the Philippines was initially under the Spanish colonial rule, and this was the governing law. And subsequently, we've been under the American colonial power, and we have the torrent system. All lands granted under the Spanish mortgage law, not covered by a certificate of title issued under the torrent system, will now be considered as unregistered land. So if the land is not registered under the torrent system, it's considered as unregistered land after the phasing out of those titles under the Spanish mortgage law. So there has been a deadline set for those persons who claims ownership by virtue of this Spanish mortgage law. So what is the purpose of the torrent system? First, it is to quiet title of land and to stop forever to any question of the legality of the title except claims which were noted at the time of registration in the certificate or which may arise subsequent thereto. Yeah. So that being the purpose of the law, it would seem that once a title is registered, the owner may rest secure without the necessity of waiting in the portals of the courts or sitting in the mirador de su casa to avoid possibility of losing his land. So you don't have to be on every inch of your land just to protect it that it's not going to be owned by somebody else of a stranger. So that's one good thing about the torrent system. Uh, the purpose of it, in other words as well, is it avoid possible conflicts of title in and to real property because it's a comprehensive system and facilitate transactions relative thereto by giving the public the right to rely upon the face of the torrent certificate of title and to dispense with the need of inquiring further, except, as mentioned a while ago, when the party concerned has actual knowledge of facts and circumstances that should impel a reasonably cautious man to make such further inquiry. So it could be possible that the torrent system is a sham, or it could have been a duplicate which has already been cancelled prior. The torrent system is not meant for the acquisition of lands, but it is for the registration title which the applicant already possessed over the land. So that means is that it is not meant for persons. It's to acquire land, but it's only a means of registering such right over the land. Registration was never intended as a means of acquiring ownership. So what is the nature of land registration proceedings? It is in rem based on the generally accepted principles underlying the torrent system. So in rem, it means that it is binding upon the whole world. We should take into consideration or take note of the fact that in the petition for registration of lands in the courts, it states there to all whom it may concern, and means that all the world are made parties defendant, binds all persons known and unknown, and last, the title issued as a result thereof is binding and conclusive upon the whole world. Relatedly, a decree of registration that has become final shall be deemed conclusive not only on the questions actually contested and determined, but also upon all matters that might be litigated or decided in the land registration proceedings, that is CATCHO versus CA. So what is the jurisdiction of land registration proceedings? It is vested with the RTC now. It now has or have the regional trial courts now have plenary jurisdiction over land registration proceedings by virtue of Section 2, Paragraph 2 of PD number 1529. RTC therefore no longer have limited jurisdiction in the original land registration cases, so that there's no more need for distinction between general or limited jurisdiction conferred by the Land Registration Act. And also, the Judiciary Reorganization Act of 1980, as amended, allows inferior courts in certain cases to hear and determine cadastral or land registration cases. So aside from the RTC, lower courts like the MTC, METC, MTCC may now have jurisdiction with land registration proceedings. And it has been bolstered by the Administrative Circular Number 6-93-A, dated November 15, 1995, which authorized the inferior courts to hear and decide the cadastral or land registration cases mentioned in the aforequoted law. So what is the rule prior to PD number 1529? The special and limited jurisdiction of the RTC, which did not extend to cases involving issues properly litigable in other independent suits or ordinary civil actions, have time and again been relaxed by the Supreme Court in the interest of justice. So what are the governing laws of land registration proceedings? We have the PD number 1529, or the Property Registration Decree. It amended and codified the laws related to registration of property. So because prior, there are many laws, scattered laws, and has been grouped into one under PD number 1529. This law is intended to strengthen and simplify registration proceedings and the issuance of certificates of title. Also, this law covers original registration title. This original registration title covers two. We have ordinary registration proceedings and cadastral registration proceedings. PD number 1529 also involves registration of voluntary and involuntary dealings with registered lands. Voluntary, it's with the instance of a private person, and involuntary dealings, it's with the instance of the state. And the reconstitution of lost or destroyed originals of torrents title. So PD number 1529 has related laws under Land Registration Law Act number 496, which took effect on 1903. It also has relation with Public Land Act, which is a law during the Commonwealth period in 1936. And we have Republic Act number 26 of 1946, which a law about the reconstitution of torrents title. So that ends our discussion. To recap, we've discussed the purpose of the torrent system, which is to quiet title and facilitate transaction. Its nature is in rem, and it's binding to the whole world with respect to the registration proceedings. The jurisdiction with such proceedings is under the RTC and as delegated under the inferior courts, the MTC, METC, and MCTC. And the governing laws of the torrent system is Act number 496, Public Land Act, and Republic Act number 26. Thank you.
Good afternoon. For today, I'll be discussing the topic regarding administration of torrent system. To jumpstart our discussion, I'll be sharing with you on screen a PowerPoint presentation in order to guide us in our discussion of the aforementioned topic. Chapter 2, Administration of Torrent System. I have three objectives for this discussion. Number one, to define and provide the functions of Land Registration Authority and its administrator. Second, to provide information with regard the Register of Deeds and its functions. And third is to give information when Register of Deeds may deny registration of voluntary instruments.
Wow!
First, as to the Land Registration Authority. The Land Registration Authority is the agency of the government charged with the efficient execution of the laws relative to the registration of lands and is under the executive supervision of the Department of Justice. This is specifically stated under Section 4 of PD 1529. Now, who heads the Land Registration Authority? The authority is headed by an administrator and is assisted by two deputy administrators, all of whom are appointed by the President of the Philippines upon recommendation of the Secretary of Justice. What are the functions of the authority? Well, first, the authority shall extend speedy and effective assistance to the Department of Agrarian Reform, the Land Bank, and other agencies in the implementation of the in the implementation of the land reform program of the government. Second is to extend assistance to courts in ordinary and cadastral land registration proceedings. And third, be the central repository of records relative to original registration of lands titled under the Torrent system, including subdivision and consolidation plans of titled lands. Now, we already talked about the functions of the authority. Let's talk about the functions of the administrator himself or herself. The administrator shall perform the following. Number one, the administrator issues decrees of registration pursuant to final judgments of the courts in land registration proceedings and cause the issuance by the registers of deeds of the corresponding certificates of title. Later, I'll be discussing what is Register of Deeds. Second, it exercises the administrator exercises supervision and control over all registers of deeds and other personnel of the commission. Third, or the authority, because before we refer to Land Registration Authority as Land Registration Commission, but now LRA is already called authority and no longer commission. Third, he or she resolves cases elevated en consulta by or on appeal from decision of the Register of Deeds. Fourth, the administrator exercises executive supervision over all clerks of court and personnel of the courts of first instance, now regional trial court, throughout the Philippines with respect to the discharge of their duties and functions in relation to the registration of lands. Fifth, he or she implements all orders, decisions, and decrees promulgated relative to the registration of lands and issue, subject to the approval of the Secretary of Justice, all needful rules and regulations thereof. Lastly, he or she verifies and approves subdivision, consolidation, and consolidation subdivision survey plans of properties titled under Act 496, now PD 1529. Now, who is a Register of Deeds? Well, the Office of the Register of Deeds constitutes a public repository of records of instruments affecting registered or unregistered lands and chattel mortgages in the province or city wherein such office is situated. Well, under the law, it is specifically stated that there should be one register of deed in every city or province. And that's the reason why, for example, here in Naga City, we have one register of deeds of Naga City, but we have a separate office of register of deeds for Camarines Sur, because Camarines Sur is a province, Naga City is a city. Now, what are the qualifications to be registered to become register of deeds? Um, well, no, under the law, it specifically states that no person shall be appointed register of deeds unless he has been admitted to the practice of law in the Philippines. Therefore, he has or she has to be a lawyer and shall have been actually engaged in such practice for at least 3 years or has been employed for a like period in any branch of the government, the functions of which include the registration of property. Now, who appoints the Register of Deeds? Well, obviously, it's the President of the Philippines who appoints the Register of Deeds upon the recommendation of the Secretary of Justice. The, the Register of Deeds has a Deputy Register of Deeds. Okay, he is assisted by the Deputy Register of Deeds, also a member of the Philippine Bar, and appointed by the Secretary of Justice upon the recommendation of the Administrator of the authority. What are the general functions of the ROD, the Register of Deeds? Well, specifically under Section 10 of PD 1529, it provides that it shall be the duty of the Register of Deeds to immediately register an instrument presented for registration dealing with real or personal property which complies with all the requisites for registration. He or she shall see to it that said instrument bears the proper documentary and science stamps and that the same property and that the same are properly cancelled. If the instrument is not registrable, he shall forthwith deny registration thereof and inform the presenter of such denial in writing, stating the ground or reason thereof, and or his advising him or her of his or her right to appeal by consulta in accordance with Section 117 of this decree. Now, what must be taken into consideration is that the Register of Deeds also prepares and keeps an index system which contains the names of all registered owners, alphabetically arranged, and all the lands respectively registered in their names. That's the reason why they are considered to be the register of deeds. Now, technically, the function or the duty of ROD is ministerial in character. As enunciated in the case of Baranda versus Gustillo, it stated that the function of the Register of Deeds, with reference to the registration of deeds, encumbrances, instruments, and the like, is ministerial in nature. What you have to take note of that it is enough that in the opinion of the ROD, an instrument is registrable for him to register it, and the act being also an administrative act, it does not need or does not contemplate a notice and hearing per se. Now, the ministerial character of the duty of the register instrument, the determination of whether a document is valid or not is a function not of the ROD, but such function belongs properly to the court competent jurisdiction. That's the reason why the ROD's duty is really ministerial in character. Um, what's the reason behind the ministerial character of the duty of the register instrument of the duty to register instrument? Well, in a given in a given jurisprudence specifically states that the law on registration does not require that only valid instruments shall be registered. Now, the question is how can parties affected thereby be supposed to know their invalidity before they become aware, actually or constructively, of their existence or of their provisions? Now, the Supreme Court said that if the purpose of registration is merely to give notice, then questions regarding the effect or invalidity of the instruments are expected to be decided after, not before registration. Therefore, you register first, it must follow as a necessary consequence that registration must first be allowed and and validity or effect litigated afterwards. Now, when does Register of Deeds may deny registration of voluntary instruments? Well, there are only three situations. Number one is when there are more than one copy of the owner's duplicate certificate of title, and not all such copies are presented to the Register of Deeds. Second is that where the voluntary instrument bears on its face an infirmity. And third is that where the validity of the instrument sought to be registered is in issue in a pending court suit. In this case, the registration, if there's a pending case, the registration may be suspended to await the final decision or the final outcome of the case, and the rights of the interested parties could be protected in the meantime by filing the proper notice of dispendence. Well, other pertinent information, what you have to take note as well is that the Register of Deeds may also refuse to register a private document because it provides that deeds of conveyance affecting land should be verified and acknowledged before a notary public. Because as we all know, being verified and acknowledged before a notary public would mean that the document, the subject document, will now become a public document. And it's specifically clear under the law that the Register of Deeds um, may only register public documents. What if the deed of sale was executed in a place other than where the subject property is located? Like, for instance, the deed of sale was executed in Iriga City, however, the subject property is located in Naga City. Now, the answer to that is the fact that a deed of sale was executed in a place other than where the property subject thereof is located does not affect the extrinsic validity of the instrument. What is important is that the notary public concerned has authority to acknowledge the document executed within his territorial jurisdiction. Then the notarial acknowledgement attaches full faith and credit to the document and also vests upon it the presumption of regularity. Now, what in case of doubt? Now, where, however, the Register of Deeds is in doubt as to the proper action to take on an instrument or deed presented to him for registration, he or she should submit the question to the administrator of the authority, now which is what we call the enconsultas or consultas. Thank you for listening.
Good evening to everyone. I am Sharmi Pia Balayan, a fourth-year law student, and in this short presentation, I will discuss important concepts in original registration under PD number 1529. Specifically, my presentation will cover first, who may apply for registration, second, the requirements for original registration under PD 1529, third, the persons who may not apply, and lastly, the forms and content of application.
Wow!
We first begin with the question, who may apply for registration under PD number 1529? Section 14 of PD number 1529 provides for a list of the persons who are qualified to apply for registration. First, we have those who by themselves or through their predecessors in interest have been in open, continuous, exclusive, and notorious possession and occupation of alienable and disposable lands of the public domain under a bona fide claim of ownership since June 12, 1945. Second, we have those who have acquired ownership of private lands by prescription under the provisions of existing laws. And third, those who have acquired ownership of private lands or abandoned land or abandoned riverbeds by right of accession or accession under the existing laws. And fourth, those who have acquired ownership of land in any other manner provided for by law. The first item of Section 14 refers to original registration through ordinary registration proceedings. Basically, it operationalizes Section 48, paragraph B of CA number 141, which provides for the grant of substantive right to land or right of title to land to qualified persons. Further emphasizing Section 14, paragraph 1, the requirements under this paragraph may be divided into three. First, the land applied for must be an agricultural public land already classified as alienable and disposable land at the time of the filing of the application for registration. Second, the applicant must have been in an open, continuous, exclusive, and notorious possession and occupation of the land under a bona fide claim of ownership. To remember these requisites, just take note that number two refers to OSENPO or ocean as an abbreviation. Third, such possession and occupation must have commenced since June 12, 1945 or earlier. Question: should the land be established as alienable and disposable at the time of filing of the application? The answer is no. In the case of Republic versus Court of Appeals, the court ruled that the reasonable interpretation of Section 14, Paragraph 1 is that the land sought to be registered must be alienable and disposable at the time of the filing of application. So, meaning to say, it is not necessary that the land be classified as alienable and disposable as early as June 12, 1945, or at the time when the applicant starts to occupy the same. How may an applicant prove that the land is alienable? In the same case, the Republic versus Court of Appeals, the court provided four means to prove that the land is alienable. We have presidential proclamations or executive order. We have administrative action, particularly the certification of the DNR secretary. We also have investigation reports of the Bureau of Land Investigator. And lastly, we have legislative act or a statute. In other words, there should be a positive act of the government in order for a land to be classified as or to prove that the land is alienable and disposable. For the second item, remember that it is the DNR secretary that has the authority to certify the classification of the land, which means that it would not be enough for the PENRO or SENRO alone to certify that the land is alienable and disposable. There has to be an approval as well from the DNR secretary. That is the jurisprudence pronounced in the case of Republic versus Dan Properties. Now, what we ask the question, what is the character of possession required under Section 14, Paragraph 1? To reiterate, the possession must be open, continuous, exclusive, and notorious possession and occupation. The legislative intent of using the conjunction "and" between the words possession and occupation is to emphasize the need for actual possession and not just a constructive or fictional possession of the land. Proceeding to registration under Section 14, Paragraph 2. Section 14, Paragraph 2 provides refers to those who have acquired ownership of private lands by prescription under provisions of existing laws. So while Section 14, Paragraph 1 speaks of alienable and disposable lands, Section 14, Paragraph 2 covers private property. What's the difference between the two? The distinction between the two lies with the inapplicability of prescription to alienable and disposable lands, which means that no matter how long the possession, be it from 1945 or even earlier, there can never be prescription against the state regarding properties of public dominion. In the case of Republic versus Suburban, the court ruled that the period of possession preceding the classification of the property as patrimonial cannot be considered in determining the completion of the prescriptive period, which means that, unlike the first paragraph of Section 14, The In Section 14, Paragraph 2, the land should have already been classified as patrimonial or a private property for prescription to commence, meaning prescription will not be counted, or the occupation of the land will not be counted if the land has not yet been classified as a private property, or as a private property capable of prescription. Remember, prescription does not apply against the government or the state. To emphasize more on the distinction between the first paragraph and the second paragraph of Section 14, Paragraph 1 refers to registration of title on the basis of possession, while Paragraph 2 entitles the applicant to registration on the basis of prescription. Second, Paragraph 1 is extended under the aegis of PD 1529 and the Public Land Act, while Section 15, Paragraph 2 is made available both under PD 1529 and the Civil Code. It's not the PLA, but the Civil Code. Apologies for that. Remember, as I have already mentioned earlier, Section 14, Paragraph 1 operationalizes CA number 141, specifically it's Section 48, Paragraph B. That's why it's also extended to Public Land Act. We proceed to the third item under Section 14. The third paragraph refers to those who have acquired ownership of private lands or abandoned riverbeds by right of accession or accretion under existing laws. Article 457 of the new Civil Code provides that to the apologies for the wrong slide, but Article 457 provides that to the owners of lands adjoining the banks of rivers belong the accretion which they gradually receive from the effects of the current of the waters. But for Article 457 of the new Civil Code to apply, there are three requisites that should be satisfied. First, the deposit should be gradual and imperceptible. Second, it should be made through the effects of the current of the water. And lastly, the land where accretion takes place is adjacent to the banks of the rivers. In the absence of evidence that the change in the course of the river was sudden or that it occurred through avulsion, the presumption is that the change was gradual and caused by accretion and erosion. Now, also, it should be taken note that the fact that the accretion to one's land used to pertain to the property of another estate, which is covered by the torrent certificate of title, does not necessarily preclude the other person from being the owner of the deposit. However, this is Article 457. It should be taken note that accretion does not automatically become registered land. So, accretion by itself does not confer ownership over the land. In order to acquire ownership over the land, there must be an application for registration filed for the purpose. So it is through that process that the land which has been moved by accretion may be registered under the Thorns system and form part of the land of a person or an applicant. In the absence of an application for registration, which is filed for that purpose, another person or a third person may also acquire the same property by prescription against the original owner of the deposit. We proceed to the requisites in ordinary registration proceedings under PD 1520. 1529. What are the requisites in ordinary land registration proceedings? We have 13 requisites. Go through them one by one. First is the survey of land conducted by the Bureau of Lands or a duly licensed private surveyor. We also have the application for registration by the or the filing of an application by the applicant. We also have third the setting of the date for the initial hearing of the application, specifically by the court. We also have transmittal of the application and the date of initial hearing, along with the documents or other pieces of evidence attached to the application by the clerk of court to the Land Registration Commission. It's now called the Registration Authority. For fifth, we have publication of a notice, specifically the public of a notice of the filing of the application and the date and place of the hearing in the official gazette. We also have the service of notice. We have the filing of an answer to the application. The answer may be filed by any person, whether named or not named in the application. We also have hearing of the case by the court. We have the promulgation of the judgment by the court, and we have issuance of the decree by the court declaring that the decision as final and instructing the Land Registration Authority to issue a decree of confirmation and registration. 11th requisite, we also have the entry of the decree of the registration in the Land Registration Authority. We have the sending of copy of the decree of registration to the corresponding Register of Deeds, and lastly, we have transcription or the transcription of the decree of registration in the registration book and the issuance of the owner's duplicate original certificate of title to the applicant. We now proceed to the question: who may not file or who cannot file an application for the registration of land? In the Book of AQUINO, if there were four persons specifically, there are four persons specifically disqualified to file an application for registration of land. First, we have a public land sales applicant for the same land covered by sales application. Meaning to say, a public land sales applicant cannot file for the registration of the land which is covered by sales application. By filing such application, the public land sales acknowledges that he is not the owner of the land and that the same is a public land under the administration of the Bureau of Lands. That's why he is disqualified. Second, we also have a mortgagee or his successor in interest with respect to the mortgage land. So this disqualification applies notwithstanding the lapse of the period for the mortgagor to pay the loan in which the for which the land has been secured or mortgaged. Third, we have an anti-critic creditor also cannot acquire by prescription the land surrendered to him. So in the third item, the possession of the anti-critic creditor is not in the concept of an owner, but a mere holder placed in possession of the land by its owners. Fourth, we also have a person or entity whose claim of ownership to the land had previously been denied in a revindicatory action. We proceed to the forms and content of application. Under Section 15 of PD 1529, the application for land registration shall be in writing signed by the applicant or the person duly authorized in his behalf and sworn to before any officer authorized to administer oath for the province or city where the application was actually signed. Also, if there's more than one applicant, the application shall be signed and sworn to by and in behalf of each. The content of the application are as follows. One, we have the description of the land. The description of the land should include the building and the improvements thereon, as well as the plan which was duly approved by the Director of Lands and the technical description of the land. Second, we have the citizenship and the civil status of the applicant. If the marriage has been legally dissolved, the details as to when and how the marriage was terminated should also be included. Third, the assessed value of the land and the buildings and other improvements thereon. This will be based on the last assessment for taxation purposes. We also have the mortgage or encumbrance. In the mortgage or encumbrance should be stated in the application because without such pronouncement or annotation, the applicant without such annotation to the applicant, such mortgage or encumbrance will not bind third persons. Fifth, also the manner by which the applicant has acquired the land. This has been discussed already under section 13. And sixth, we have the full names and address of the occupants of the land and those of the adjoining owners, if known. If not known, the applicant shall state the extent of the search made to find them. Under section 7, additionally, section 20 of the decree provides that if the application describes the land as bounded by a public, private way or road, it shall also state whether or not the applicant claims any and what portion of the land within the limits of the way or road, and whether the applicant desires to have the line of the way or road determined. Last requirement we have for the content of application. For item number 8, section 21 of the decree states that the court may require facts to be stated in the application in addition to those prescribed by the decree. This is the reason why the court may also conduct an ocular inspection whenever it is deemed necessary. That would be all for my presentation. Thank you so much, and once again, good evening.
Good evening, everyone. I'm from Team Plaza, and I'm the fourth reporter. My name is Razel Dimaano, and I'm going to discuss to you judicial confirmation of imperfect or incomplete title under Public Land Act, Chapter 4 in the book of AQUINO. To start off, let me discuss to you the nature of proceeding.
Wow.
The proceedings under the PD 1529, formerly under the Land Registration Law or Act number 496, and under the provision of Chapter 8 of Public Land Act, particularly Section 48B, are the same in both are against the whole world. And also both take the nature of judicial proceedings, both decree of registration issued is conclusive and final, and both proceedings are likewise governed by the same court procedure and law of evidence. Now, I'm going to discuss you the changes in law governing the judicial confirmation of imperfect or incomplete title. So this is like I'm going to walk you through to the evolution of the judicial confirmation. So to start off, we have Section 48B under Chapter 8 of Public Land Act, which took effect on December 1, 1936. And it reads, uh, the following described citizens of the Philippines occupying lands of public domain or claiming to own any such lands or an interest therein, but whose titles have not been perfected or completed, may apply to the court of first instance, which is now the regional trial courts of the province where the land is located, for confirmation of their claims and issuance of certificate of title. Therefore, under the Land Registration Act, now Property Registration Decree. And then it got repealed by PD number 1073, Section 3, which provides that the judicial confirmation of incomplete titles to public land based or unperfected Spanish grants, such as application of the purchase, composition, or other forms of grant of lands of public domain under the laws and the royal decrees in force prior to the transfer of sovereignty from Spain to United States shall no longer be allowed. However, this section shall not be construed by as prohibiting any person claiming the same land from acting under Section 48B and Section 48C if it meets the conditions and prescribed judicial confirmation of his incomplete title here under. Now, those who by themselves or through their predecessor in interest have been in an open, continuous, exclusive, and notorious possession and occupation of what agricultural lands of public domain under the bona fide claim of acquisition of ownership, except as against the government since July 26, 1894. Mind you, that's July 26, 1894, except when prevented by war or force majeure. And these shall be conclusively presumed to have performed all the conditions essential to the government grant and shall be entitled to a certificate of title under the provisions of this chapter. Then we move on to the amendment. So after that, we now have Section 48. As we remember, Section 48 of Public Land Act, it got amended by RA 1942. So the change specifically from July 26, 1894, they changed it to for at least 30 years immediately preceding the filing of the application. So everything is the same. They just changed that date. So instead of since July 26, 1894, they changed it now to for at least 30 years immediately preceding the filing of the application for confirmation of the title, except when prevented by war, force majeure, everything is the same. All right. Now, let's move on to RA 3872, which took effect on June 18, 1964. What happened here is that they added a new subsection C to the Section 48 of Public Land Act. So we have now Section C, which provides that members of the national cultural minorities who by themselves or through their predecessor in interest have been in open, continuous, exclusive, and notorious possession and occupation of lands of public domain suitable to agricultural, whether disposable or not, under the bona fide claim of ownership for at least 30 years shall be entitled to the rights granted in subsection B. So they are also allowed to apply under a judicial confirmation proceedings to for an imperfect or imperfect or incomplete title. Now, next. After that, we have Presidential Decree 1073, which promulgated on January 25, 1977. So they actually further amended subsections B and C of a public act. So just to highlight, they just amended the term to alienable and disposable lands of public domain. If you can observe, they actually remove the term agriculture, agricultural lands of public domain. So they replace it with the amendment, replace it with the alienable and disposable lands of public domain. And also, mind you, if you can observe, remember, they changed it to at least 30 years. Now, under this law, they now changed it to June 12, 1945. So I guess that explains why, if you're going to read the PD 1073, or it will show that the claim and acquisition of ownership, it should be since June 12, 1945. Right? Next, extended periods for filing applications. So we have now here, I'm just going to walk you through to the extended periods for filing the applications. So, it would be easier if we have pictures, right? So, at start, they had it pegged until December 31, 1938. That is through Section 47 of Public Land Act, and also in the case of Director of Lands versus Dano. The time limitation within which to file the application for confirmation of imperfect or incomplete title was actually not extended, and not to extend beyond. It was given until December 31, 1938 back then. Now, we have the Commonwealth Act 292, Section 2, approved on June 9, 1938. They had it moved on December 31, 1941. And next to that is RA 107, which was approved on June 2, 1947. They moved it to December 31, 1957. And next, we have RA 2061, approved back in June 13, 1958. And they extended it, the period for filing, up until December 31, 1968. And also, they had another amendment, that is RA 6236, approved on June 19, 1971, and they move it to December 31, 1976, until another one, PD 1073, they move it up until December 31, 1987. And also, they had RA number 6940, which was approved on March 28, 1990, and they had it extended up until December 31, 2000. And finally, I guess this is the last time. I'm not sure though if they're going to extend this. They have another RA number 9176. Under this, under Section 2, which was approved way back November 13, 2002, they extended the period for filing an application up until December 31 um, of 2020, of this year. So, up until December 31 of this year. Next. So, under Section 2, Section 47 of Chapter 8 of the same Act as amended is hereby further amended to read as follows. So we have now amendment here. It states in that mentioned extension that the persons specified in the next following section are hereby granted time not to extend beyond December 31, 2020, within which to avail the benefits of as the judicial confirmation for incomplete title, that is provided that this period shall apply only where the area applied for does not exceed 12 hectares. So, as you can observe, we have now a limitation when it comes to the area. Provided further that the several periods of time designated by the President in accordance with Section 45 of this Act shall apply also to the lands comprised in provisions of this chapter and not construed prohibiting any said person from acting under same chapter prior to the period fixed by the President. And even without the extended periods under said 6940 and RA 9176, persons who possess the qualifications as mentioned under Section 49B and Section 48B and 48C of Commonwealth Act 141 as amended by PD number 1073 may nonetheless apply for registration of title under Section 14I of PD 1529, which provides for the same qualifications provided that the applied area should not exceed 12 hectares, right? And then the status of application filed after every expiry of extended periods. We have here a landmark case, Director of Lands versus Abayro, wherein the petitioner contended that the respondent here should have dismissed the application for registration based on an imperfect or incomplete title because it has no jurisdiction over such petition. As according to the petitioner, as it was filed on March 1, 1971, and after December 31 of 1968, the expiry date for filing such application already happened. So, according to them, the case should be dismissed. And however, as we can observe, there's a latest extension of the period, which is December 31, 2020, which to file said applications. And then it just provided that they have to limit it to the area limitation is 12 hectares. So, according to the court, it was actually clear that applying such the judicial confirmation of the title prior to the cutoff of December 31, 1976, such application was filed, may still be heard by the court. So when it comes to according to the court, Section 47 of Commonwealth Act number 141 uh, expressly includes the proviso that it shall not be construed as prohibiting any said persons from acting under the mentioned chapter and the period fixed by the president. So, no period has been fixed by the president despite the authority granted by him as a first proviso. So, in absence of the said proviso, though, the basis of the petition would be too technical and merit serious consideration. So, since December 31, 1976 by our so until since it was extended the extension until December 31, 1976 of RA number 6236 for filing of such application retroacted to and covered the applications filed after January 1, 1969 and before June 1971. So the application filed on March 1971 could be considered as refiled after the effectivity of RA 6236. Then that is according to the Supreme Court less than 4 months thereafter. So in that case, according to the court, it should be given to the obvious intention of the lawmaker in extending the period for filing such applications. Hence, they granted such petition and did not dismiss it under such ground. Now, for the limitation of area applied for, as remembered earlier, um, when we had the original text of the judicial confirmation, it doesn't limit the area as we can observe. However, through later time, when they have amended the law, they now limited it to a specific number of hectares. So just to run through and give you like the history of such, here we are. We have the limitation of area to start off under RE number 6236. It actually states that it should not areas to be applied for should not exceed to 144 hectares. So that's the original limitation given under RA 6236. Then it got amended under PD 1073, which provided that the extension shall apply only where the area applied for does not exceed 144 hectares. Until such time, the latest, the one that we are using, that's RA 6940, which states that it shall apply only where the area applied for does not exceed 12 hectares. So for the judicial confirmation of an imperfect or incomplete title, there is now a limitation of area for application. It should not exceed 12 hectares. Originally, it was way back June 1971. That was the limitation is not exceeding to 144. It's now down to 12 hectares. Okay. Now, let's go to the applicants. So, who could be the applicants for the judicial confirmation? So, by law and the jurisprudence, the following may therefore apply for judicial confirmation of their imperfect or incomplete title. So the scenario, you should have an imperfect and incomplete title. And one, if you are a Filipino citizen who from your predecessor in interest have been in an open, exclusive, so that's ocean, open, exclusive, oh no, open, continuous, exclusive, notorious possession and occupation of an alienable and disposable lands of the public domain under bona fide claim and acquisition. So that's since June 12, 1945 or prior thereto or even since time immemorial. So remember, that's the latest now, June 12, 1945. They removed now the 30 years from the application. Second is that Filipino citizen, same with predecessor in interest that uh, have been prior to the effectivity of 1073 on January 25, 1977. Ocean again, open, continuous, exclusive, and notorious possession and occupation of agricultural lands of public domain under the bona fide claim of acquisition of ownership. For this one, it states here for at least 30 years or at least since January 24 of 1974. So they are so allowed. And then third is that private corporations or associations, they're actually allowed to apply for judicial confirmation. How? Which had acquired lands, which is formerly part of an alienable and disposable lands of public domain. From Filipino citizens who had possessed the same in the manner and for the length of time indicated under subparagraph 1 and 2. So we have the length of time, June 12, and then for at least 30 years, should not exceed January 12, 1945. Now, lastly would be a natural born citizen of the Philippines who have lost their Philippine citizenship, who have acquired disposable and alienable lands of the public domain from a Filipino citizens who possess the same in the same manner and length of indicated subparagraph 1 and 2. So we have first subparagraph 1 and 2, all Filipino citizens with, we should not forget the length of time from 1 and 2, and then private corporation and association, lastly, natural born citizens who have lost their Philippine citizenship. So these are the persons allowed to apply for the or entity allowed to apply for judicial confirmation of their imperfect or incomplete title. Now, let's move to what applicant must prove. All right. So first, we have that the land is alienable and disposable land of the public domain. So that's the first thing. Second is that his possession must be for the length of time in the manner and the concept stated under Section 48B, as we have reiterated earlier. And then, to prove that the land is alienable, he must secure certification from the government that the lands which he claims to have possessed or owned as owner for more than 30 years or since June 12, 1945 under PD 1073 are alienable and disposable. It is the burden of the applicant to prove its his or positive averments. Now, so those are we move on to the meaning of the required possession. So, according to the book, possession and occupation, there's actually a difference, and that's why there's a conjunction used by the law and. So the intention of the law, there must be they are actually not synonymous. So possession is broader than occupation because it includes constructive possession. So when the law adds the word occupation, it seeks to delimit an all-encompassing effect of constructive possession. Taken together with the words open, continuous, exclusive, and notorious, the word occupation serves to highlight the fact that one, to qualify under paragraph B, or aforesaid section 48, his possession of the land must not be mere fiction. So possession is open when it is patent, visible, apparent, notorious, and not clandestine. So It is continuous and interrupted, unbroken, and not intermittent or occasional. Exclusive when the adverse possessor can show an exclusive dominion over the land and the appropriation of it to his own use and benefit. And the notorious when it is so conspicuous that it is generally known and talked of by public or by people in the neighborhood. So these are the requirement that you have to approve also uh, in applying the judicial confirmation. Now, what is the effect of compliance with the requirement? So, according to the provision section 48B of public land, um, the possessor is deemed to have acquired by operation of law a right to a grant, a government grant, without the necessity of a certificate of title being used if you have complied with the requirements. Now, the land ceases to be public domain and it would be beyond the authority of director of lands to dispose of. And the application for confirmation is then it's just a formality, the lack of which does not affect the sufficiency of the title as it would be evidenced by the patent and the corresponding torrents title issued pursuant to such patent. So it should, however, be noted and emphasized that the above provision of the law applies exclusively to public agricultural land, which are alienable and disposable. Right? Now, we go to, as mentioned earlier, we have private corporations or associations as applicants, right? So we discuss further. What about that? Now, as we can remember in our discussion in our Consti law, in 1973 Constitution, it actually explicitly provides that no private corporation or association may hold alienable lands of public domain except by lease not to exceed 1,000 hectares, right? And then in our 1987 Constitution, it also provides that private corporation or associations may not hold such alienable lands of the public domain except same to through lease. It's just that they added except by lease or by period not exceeding 25 years. So we have here the time limitation. Renewable for not more than 25 years and not exceed 1,000 hectares in area. So same with 1973. However, what the Constitution actually bars is that the situation wherein it is clear that if the land is still part of the alienable and disposable lands of the public domain, at the time the corporation or the association files for the application, so let's say our corporation applied for it, and then it's still part of the public domain, um, and I applied for the confirmation of imperfect or incomplete title, such application is a we can now apply the constitutional bar. So it's not allowed under our constitution. However, on the other hand, what the constitution what is allowed is that um we it has been held that the prohibition in the said constitution against a private corporation or association acquiring lands of public domain do not apply where at the time of such corporation acquired the land, the predecessor in interest by exclusive, continuous, and adverse possession and same probably for 30 years and had acquired ownership, they already had an ownership acquisition. So in ipso iure, and then later they conveyed the title to the corporation. So in that case, that is allowed, right? So that means you have to have an ipso iure, or you should have at least acquired an ownership coming from a private person. And then that's the only time that the constitutional prohibition will be will actually not be applicable in such situation, right? So, I guess that's clear. Hence, the private corporation or association, as they can be applicants also in that case, provided that they got it from a private person or an individual. All right. Next. So we have here a discussion of director of lands versus intermediate appellate court or and ACME, and the significant and the precedent setting rulings on the matter. So number one, notwithstanding to the prohibition of the 1973 and 87 Constitution against private corporation holding lands, except for the lease, as mentioned earlier, confirmation proceeding under at the time of the institution of registration proceeding, the land was already private land. On the other hand, if the land was still part of the public domain, then a private corporation cannot institute such proceedings. We just have to remember that. Then the correct rule is that alienable public land held by a possessor personally or through predecessor in interest openly, continuously, exclusively for the prescribed statutory period, let's say 30 years, is converted to private property by the mere lapse or completion of the said period or ipso iure. And then that under Section 48B, possession of the public land, which is in the character and duration prescribed in statute, the confirmation proceedings would in truth be little more than a formality. So that in that case, as mentioned earlier also, it's as if the predecessor in interest, which is a private owner, has ripened its ownership to such property. Hence, in that case, if the said corporation applied for a judicial confirmation, then it will be allowed. Such proceedings will be allowed by law. Then let's move on. What else according to this case? So, purely accidental circumstance that confirmation were brought under 1972 Constitution, and well, we have discussed this, so we don't need to dwell on this portion. Same under the ruling of in the ruling of the Supreme Court, it actually held that the Constitution do not apply to public lands already converted into a private ownership by the natural person. So in that case, if there is a subsequent conveyance of such property, then such corporation is entitled now for a judicial confirmation or for such proceedings. All right. So next, form and contents of application. So we have to remember under Section 50 of Public Land Act provides that the application for judicial confirmation of imperfect or incomplete title shall conform nearly as may be in its material allegations the requirements of the application under the Land Registration Act, now properly known as PD 1529. And also should state that application the material facts, information required under Section 15. And then original registration under aforementioned act invariably invoke in their application the benefits under Chapter 8. As mentioned earlier, you have to prove one of the requirements, such as you have you have a possession of such land, and also you have a open, continuous, exclusive, and notorious possession of such land. So those are one of the requirements required by the law. And then we now go to the confirmation of title over the land previously declared public land. So I'm just going to give you the case of Mindanao versus Directorial Lands. PU Mindanao and his co-heirs filed a land registration case under Act number 496, alleging that they inherited the land involved from their grandfather, and alternatively invoking Section 48B. And since their predecessor interest had continuous possession of the land adversely in the concept of an owner for more than 30 years immediately preceding, hence they filed for the application, filing for the application. And Vicente de Villa opposed the application on the ground that it's res judicata, contending that the land was previously declared public land in a decision in 1949 in the land registration case filed by Villa, and that Mindanao were not oppositors to such earlier case. And then the Director of Lands and Director of Forestry also opposed to such application. Now, the ruling in favor of Mindanao heirs right to apply for registration. So the Supreme Court held that according to the Supreme Court, it should be noted that the appellant's application in the alternative for registration of their title of ownership under Act 496, or for the judicial confirmation of their imperfect title or claim based on the adverse and continuous possession for at least 30 years, it may be that although they were not actual parties of the previous case, the judgment therein is a bar to their claim as owners under the first alternative, since the proceeding was in rem, of which they and their predecessor had constructive notice by publication. So even so, this is a defense that properly pertains to the government in view of the fact that the judgment declared the land in question to be public land. So in any case, according to the court, appellant's imperfect possession of title was not disturbed or foreclosed by such declaration for precisely the proceeding contemplated in the in the provision of Commonwealth Act 141 presupposes that the land is public, and then the basis of the decree of the judicial confirmation authorized therein is not the land in area privately owned and hence no longer of the public domain, but rather that by reason of the complainant's possession for 30 years, he is conclusively presumed to have performed all the conditions essential to a government grant. And even a decision in the cadastral proceeding declaring the land as a public does not bar a subsequent application for judicial confirmation of the same land. In the case also of Director of Lands and Court of Appeals, it was held that a judicial declaration that the parcel of land is public does not preclude even the same applicant from subsequently seeking a judicial confirmation of his title to the same land, provided thereafter they comply the, as mentioned earlier, Section 48 of the Commonwealth Act 141 as amended, as long as the said public land remains alienable and disposable. So, so all right. So that would be all. Thank you for listening. I hope you learned a lot. Thank you. Good evening.